Good morning, friends. We are going to discuss the sand policy 2019 by the AP government and the legal fiction as to whether the judicial magistrate is competent to release the vehicle or the subjudicial magistrate. This is the core issue. But anyway, let's discuss about the topic, then only we'll have definitely some knowledge. First of all, the sand policy, of course, it is a natural resource, you all know. So sometimes people say it is handed over to Dwaka groups, sometimes free for all, sometimes they will collect some toll taxes or these things. So totally confused affair. Anyway, the law governing the sand policy in Andhra Pradesh is Mines and Minerals within brackets Development and Regulation Act 1957. Particularly section 15 of the act says that nobody should take away the natural resources. Before that, let us go to the directive principles of the state policy. So if you go to Article 39 subclass B of the Directive Principle of the Constitution of India says that the natural resources should be distributed so as to subserve the common good. That means they should be subserved to all the people alike. There should be no discrimination. That means the essence of the natural resources should be reaped by each and everybody. That is the interest the government will have, or the Constitution says, Article 39 M4Js. So taking advantage of the same. Right, now the new sand policy has been there. It has always been a controversial issue. Even the National Green Tribunal, it has imposed a fine of 100 crores on AP government since it could not control the illegal sand mining near Udandiran and other places. You may be knowing the case of Vanajakshi, the Tahsildar, with that Dendalur MLA Prabhakar. All these issues you know very well. But anyway, our point is, who has to release the vehicle if caught by the police? This is more important. Normally, whenever the police see a vehicle being transported with the illegal sand, normally they arrest the owner or occupier of the vehicle under section 379 IPC, and the sand will be seized under section 15 of the Mines and Minerals Development and Regulation Act 1957. This is the common practice, right? After that, they will produce the same before the subjudicial magistrate, or if he is authorizes, then before the Tahsildar, right? This is for what? For interim custody. Please realize it is for interim custody, right? So now the point is whether the subjudicial magistrate, means RDO or Tahsildar, can release the vehicle or not. This is the main point. After taking some bond or some things, they will release. But here the correct position is that the judicial magistrate is competent to release the vehicles, not the subjudicial magistrate. This is what I want to tell you now. This has been decided way back in 2015 itself in the High Court of Kerala. So this is a case relating to High Court of Kerala. You may be knowing that court is in Ernakulam or Cochin, right? So single judge P. Ubaid, UBAID, while disposing criminal CRL MC number 294 by 2015 on 12/2/2015 in the case of Kumkuma Priya versus State of Kerala, right? He held that the judicial magistrate is competent to release the seized vehicle. That's all. But for interim custody, it can be handed over to the subjudicial magistrate. Now let's go into the case facts. So it so happened on 24/12/2014, the SI of police Payyanur police station, he found a vehicle transporting the sand illegally near some river bed. Okay. protection of river. I will tell you the name of the river also. Anyway, so he has found the vehicle being transporting the river sand illegally. So immediately he arrested, he took charge of the vehicle bearing number TN605055. He registered a case under Kerala Protection of River Banks and Regulation of Removal of Sand Act. He booked a case against them and produced the vehicle before the RDO or subdivisional magistrate for interim custody. Now, the plaintiff, that is Kumkuma Priya, owner of the vehicle, then she filed a petition before the Honorable SDM, subdivisional magistrate, to give interim orders for release of the vehicle. Yes, he agreed. But he has put conditions. He has put condition that 30% of the value of the amount should be deposited in the SDM's office, whereas for the rest of 70% of the cost of the vehicle, he has to give bank guarantee. And this order was given on 26/12/2014. Agreed by the order of the court, then the petitioner challenged it before the Honorable High Court of Kerala. So he says that the subdivisional magistrate has no power to order for interim custody. Even though he has got it, is totally unreasonable and onerous. Actually, the judicial magistrate of first class under section 451 CRPC is competent to release the property. Or please refer to section 23A of Kerala Protection of River Banks and Regulation of Removal of Sand Act, says that within 48 hours of the seizure, the report of seizure shall be sent to subdivisional magistrate. That's all. But that is only for interim custody, not for release. Suppose there are occasions where the police will seize the sand under 102 CRPC also. It means suspected to be stolen property. In such a case also, they have to be produced before the SDM. But of course, for release, the judicial magistrate is competent. That's why section 451 CRPC, it is coming into picture. Now please remember, not the subdivisional magistrate. He is there only to give interim custody, that just like our Essential Commodities Act, EC Act. Suppose if some rice bags which are being transported to Madras Harbour or some, they were seized, normally they will be seized by the concerned department or the police and they will be handed over to the joint collector, that is the additional district magistrate, for interim custody. No doubt he will order the interim custody, saying that these bags have to be deposited, they have to be kept in so and so go down. That's all. He cannot order for a release of the vehicle. Actually, that is the law. Of course, EC Act a bit different because under EC Act, joint collector is competent. But anyway, as far as our in the AP new sand mining policy 2019 is concerned, definitely we take the provisions of section 15 of the minerals, that is Mines and Minerals Development and Regulation Act 1957, and take the persons to the court of law, and the JFCM or judicial magistrate is only competent to release the vehicle and to give conviction also. I think you may be knowing the first conviction came from Kadapa district in 2019. One Nanjal Subarayudu, yes, Nanjal Subarayudu of Kadapa, he was convicted for 3 years by JFCM, 3 years, and also he was imposed a fine of rupees 10,000 for illegal transporting sand from Papagni riverbed. This is the first case, good case. Anyway, so please remember, it is for the judicial magistrate to order for the release of the vehicle, order for release of the property, not the subdivisional magistrate. The subdivisional magistrate is there only to give interim custody because the property is likely to decay, further natural decay should not be there. Only for that purpose they will ask you to keep the property for interim custody, not for release. Here this mistake has crept in. Therefore, please study the case law and enrich your legal knowledge. Thank you.